And joining us in studio, Marius du Toit from Du Toit Attorneys. He's a criminal lawyer, and we have Willie Spies, the advocate for Paul O'Sullivan, or Paul O'Sullivan's lawyer. We also have our resident political analyst, Fiso Mahlangu. I'll start with you in studio. Thanks so much for joining us, and good evening. And I suppose the question from a legal point of view is this permissible by law to be granted the safety net, if you will?
It's definitely something that I haven't come across in my practice, where I've seen where the courts have granted a reprieve of 48 hours to say that you can't be arrested unless a notice was given. But I think more importantly, we have to say there's a history to this matter, and this history has resulted at some stage or another that Mr. O'Sullivan obtained a court order wherein the court stated he cannot be arrested unless the notice is given. So the fact whether one might have to debate or want to debate the legality of it is, it's open to the state to have appealed that court order if they felt that it wasn't fair or it wasn't in line with the Criminal Procedure Act. So bar that, it remains in force, which means they have to abide by it. And if they don't abide by it, the arrest is unlawful.
Yeah, let's just get Advocate Willie Spies, whether this, as Marius is saying, that the state could have reviewed it or it could have been repealed, just from a legal point of view. I know that it is binding, but is that an option that the state could have exercised if they found that this particular order is not procedurally correct?
We should just keep in mind that this order was not the result of argument in court. It was the result of an agreement between the parties. The parties to the agreement was the Minister of Justice, the Minister of Police, the National Director of Public Prosecutions, and the various generals who are involved in this very specific matter. So this was not adjudicated by a court. It was an agreement that was reached. The police were fully aware of this agreement, and despite the fact that they were aware of this agreement, despite the fact that through a letter by the state attorney they committed themselves to doing this, they went back on their undertaking and they arrested Mr. O'Sullivan yesterday.
All right, and Advocate Spies, there's also questions in that under this particular protection, if you will, if it's something that is unprecedented, or whether it's common practice that it's afforded to person of interest, why particularly Paul O'Sullivan then?
The reason for that order, it's not that unprecedented. Mr. O'Sullivan brought this civil application last year. And the reason for the application was that the police showed a tendency of arresting him at instances where it could cause maximum humiliation, maximum embarrassment, and a maximum infringement on his dignity. The previous arrest that was made on Mr. O'Sullivan was made when he was about to leave on holiday with his two daughters and his family. And he was physically removed from a plane that was heading overseas for this arrest. That was the kind of actions that's been taken by the police in the past. So we did undertake this application in order to protect Mr. O'Sullivan's rights, in order to ensure that the police would not repeat this kind of action. Despite the fact that we undertook this application, despite the fact that the police consented to an order in November last year, they just carried on, and despite the fact that this order has been read out to the brigadier who did the arrest yesterday, he carried on, he arrested Mr. O'Sullivan, and he took him to the police station. This is a serious example of contempt of court. It's not an example of unprecedented court orders. It's not an example of special treatment. It's an exceptional example of the state that's acting in contempt of court.
All right, Advocate Spies, how I understand it is that it is a contempt of court in the sense that it was an agreement between the police and the Commissioner and IPID for Paul O'Sullivan due to the victimization, the fact that he was being victimized according to his attorney. You said that this is not precedented.
No, it's not something that you find that often, but let's be honest, Cindy, where the SAPs have abused their power, the courts have often intervened and given orders to the effect that this and this person should be released immediately. Now, where there is a history of the police abusing their power, arresting a person on frivolous, trumped-up charges, especially late in the afternoon, so the person has difficulty suddenly getting to court and being granted bail, then there's an agenda to it. And in those instances, the court do intervene. But is it something you find every day? No, I'm every day in the courts. It's not something you find every day in court. But does it exist? Absolutely. And in those special cases, the courts will do that and will, in fact, protect the accused from being abused in this manner.
Yeah, but I mean, the police would have had knowledge of this before they go and arrest Paul O'Sullivan, saying that there's this order that requires them to notify him in 48 hours. It still doesn't make sense to me that if somebody who's regarded as a flight risk, and all the charges, including victimization of our journalists, breaking the law in effect, is still given this kind of privilege.
Well, I don't doubt for a minute that Mr. O'Sullivan's advocate is paid to say the things he says. So speaking to us tonight, he is able and willing to defend his client. It comes with a job. But what he's saying is in fact untrue. I do also believe that the police did not do their best and they possibly stuffed up this case. But it doesn't mean that just because there is a deal between him and the police, and I believe Mr. Phahlane is aware, because O'Sullivan, feeling victimized, wanted a deal with the High Court and they granted a court order. But it doesn't mean that just because there is a court order, he should not be arrested. If one is arrested according to the law of this country, he will be charged. He might have slept at his home last night, but that doesn't mean that this case is null and void. The law must still take its course. So whether or not he went home last night, I think is immaterial. Some of us believe he should have spent the night in jail because many people do once they are charged. But to suggest that the police want to charge people on Friday night so that they can spend the weekend in jail, well, a weekend and night in jail, that's immaterial. The fact is, if someone has committed a crime, they will be charged and they will do the time.
I might not completely agree with Sophie. So I don't think in this instance there wasn't a history where Mr. O'Sullivan's rights have not been breached continuously by SAPS. But I think there's an important aspect which Sifiso highlighted. If this is not a blanket amnesty to say that you can never arrest Mr. O'Sullivan, if he goes, for argument's sake, tonight and he goes and perpetrates an armed robbery at a shopping center or wherever, of course the cops must and should arrest him immediately. You can't then say, well, we give you 48 hours notice. If he raped the victim, of course you have to act. But in this instance, we are now dealing with offences which happened in the past, number one, and it's offences which most probably have been dealt with in some form or another in court. And now you have to ask yourself, if the cops want to now say we want to disregard this arrangement of 48 hours, then they must be absolutely sure that there's grounds for doing so. And if there isn't, the courts will intervene, and that's what happened last night. The courts intervened.
Yeah.
So there was no basis for it.
Just your response, Advocate Spies, on the number of issues that were raised, in the sense that it seems there's a blanket amnesty for Paul O'Sullivan. We saw the concerns raised by the acting police commissioner, saying that he is both the referee and the player. He's the witness and also essentially leading the investigation and tutoring witnesses as well. That in itself, for me, is legally inappropriate.
Yeah, if I could just, from the outset, write a couple of inaccuracies in the reports that are being flashed on your screens right now. In the first place, I'm not an advocate, I'm an attorney, so please do not refer to me as advocate in the first place. In the second place, Mr. O'Sullivan is not a flight risk. By stating that, you are actually preempting a court process. You're actually preempting the outcome of any bail applications that may follow, and you are actually trying to play judge over the television, which is not acceptable. So I think for a start, let's stop judging Mr. O'Sullivan's actions over ANN7, and let's leave that to the courts to decide. So let me tell you why Mr. O'Sullivan is not a flight risk. He has been charged with a whole range of frivolous and vexatious charges being trumped up by various police officials, senior government officials, and various other people involved with organized crime. He's been charged by those people, and he's been arrested by the police. Charges are being pursued against him. those charges do not progress in any way whatsoever. In one matter that was due to be heard on the 25th of January in Kempton Park, the state closed their case, and after the state closed their case, a very convincing argument was made out by Advocate Barry Roux on behalf of Mr. Paul O'Sullivan that the state did not succeed in showing a prima facie case against Mr. O'Sullivan. This happened early last year. Since early last year, the state has failed to deliver their heads of argument answering the argument of Advocate Barry Roux. There was a second appearance in October last year. The state said, well, our arguments are not ready. And there was another appearance on the 26th of January this year when the state once again said, well, we are still not in a position to answer the arguments of Advocate Barry Roux. So what do we have? We have a prosecuting authority and a police force that are abusing processes, that are abusing the powers that they have, and that are using it in a way that embarrasses Mr. O'Sullivan and humiliates him and take away his dignity.
Yeah,
and that is what we are against. So let me tell you why he is not a flight risk. He has visited overseas destinations on various accounts over the past year and a half with the full knowledge of the state, with the full knowledge of the police, and with the consent of the police, and each and every time he returned.
All right.
That's a clear and a present example that he is not a flight risk.
Mr. Spies, if you'll give me an opportunity to respond. All right, so I've given you a fair amount of time to respond. The issue, though, just in his demeanor and his behavior, this has been reflected on the people that Mr. O'Sullivan has been pursuing. We're also quoting Mr. Phahlane, who feels heavily prejudiced in the conduct that Paul O'Sullivan has. The fact that he has a carte blanche and he's intertwined in the case against him. We understand the history behind it, but we're not playing judge. These are facts that are in the public domain that we merely ventilating with you, sir. So having said that, Sfiso, we understand that it may not be a flight risk, but there has to be questions as to why there seems to be the special treatment or kid gloves around Paul O'Sullivan. Is it a political game or grandstanding? We don't know. We just need to get to the bottom of it.
Well, a man like Paul O'Sullivan only needs 48 hours to conclude or to dismiss his case, to hire agents, to get a new passport, to become the flight risk that he's not advocate but attorney claims he is. The reality of the matter is a person of his mechanism, a person of his legal knowledge or lack thereof can perform many rituals, can perform many acts, and a lot can happen in 48 hours. What I think the SAPS owes us is an explanation to say why this deal was granted in the first place. And having been aware that this order was given, they still went ahead and arrested him. Well, they will not arrest him just because there's an order. And I think that is what happened last night. But a lot can happen in 48 hours. And so the questions will arise to say, can money buy you amnesty or buy you immunity? Mr. Paul O'Sullivan is very rich. He's very well connected. Everyone knows of his reputations. Many writers across the broad, political and media spectrum are calling for him to declare his overseas contacts because he's got very specific and very philanthropic contacts overseas. So he only needs 48 hours to perform the acts that he would perform. Now, what I think the courts and the SAPS need to account for is why this 48 hours was necessary. He is a flight risk. He's entered and exited this country illegally. He has been charged with that. I don't know why we're ignoring that fact. So he can do anything. A man cannot, be virtuous to having performed illegal actions. And then just because we look at him and say, well, the police might be monopolizing or oppressing him, let's overlook that. They should treat him as they treat everybody else. If he's committed a crime, he must do the time. What must happen within these 48 hours? It sounds to me like someone is suggesting that we give him time to find a narrow escape. That doesn't sound like justice to me.
Marius, your thoughts on that, especially if it's something that is not common practice?
We have to remember that any person that's arrested has 48 hours to be brought before court. Within 48 hours, you have to be at court. That's the first thing. If the cops decide to exercise their discretion, and I think that's the important thing, the cops here exercise their discretion to say, we are prepared to grant you a 48 hours reprieve that we won't arrest you. If one wants to question that, of course, you can bring that into question. You can ask why the cops entered into such an agreement, what was the basis of it, what was the motivation behind it. There's a number of things you can look at. But realistically speaking, the cops entered into it. So to go afterwards and say, well, listen, it's the 48 hours is now untoward, would be disingenuous, because then you are saying in actual fact, well, the cops should never have entered into the agreement in the first place. And if they had entered into the agreement, which they obviously had, then of course they have to honor the agreement. So in this instance, we have to say that Mr. O'Sullivan is within his rights to say, listen, you guys have arrested me once again without giving me notice. This is your own agreement that you're not honoring. And as a result, I have the right to approach the High Court urgently to be set free.
Yeah.
So he's only exercising his rights, which is afforded to you and I as well.
Okay, Mr. Spies, just in closing, just your response to the panelists and also the counter charges that Mr. Paul O'Sullivan and Ms. Trent are said to lay against the police that arrested them. Mr. Spies? Hello, Willie? Yeah, you're still there?
Yes, I'm there.
Yeah, just your response, and maybe you can give us some more details around the counter charges that Mr. O'Sullivan and Ms. Trent are likely to lay against the police that arrested them.
Well, we are still considering the options available to them. Obviously, there is room for civil action, and we will most certainly take on the civil action. With regard to the application that was brought last night, there was a very specific prayer within our court application for contempt of court. We did not ask the court to adjudicate on this matter. We actually removed the matter from the roll. The matter was not struck off the roll. It was removed from the roll by consent between all the parties, leaving us with the opportunity to re-enroll it, to argue the costs, as well as the prayer that we've been asking for in respect of contempt of court. We are pursuing that, and we will be pursuing that, and if criminal action would follow from that, we will do so.
All right, attorney for Paul O'Sullivan, that's Willie Spies. Thanks so much for joining us. Marius du Toit from du Toit and Associates, a criminal attorney. Lovely having you. We'll take a quick ad break, and we'll see you shortly. Stay with us.